One of the questions we get from time to time is, what's the difference between a contested probate case and an uncontested probate case? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust in Lawrenceville, Georgia, and I'll answer that question in today's video. So the question for the day is, what's the difference between a contested probate case and an uncontested probate case? Well, it probably sounds a lot like the answer is in the name. There's a contest. There's a challenge to a will or to the way a case is being administered in probate if you have a contested case. Now, in a case where the decedent died with a will, we call that dying testate. A contested probate case might include these types of challenges. One, there may be a challenge to admitting the will to probate from any heir or interested person of the decedent, including allegations that the will was not properly executed. It wasn't properly signed and witnessed in accordance with state law. Other challenges to the will are usually going to be based upon the allegation that the decedent did not have legal capacity to sign a will. They didn't have the legal capacity. They weren't in their right mind, couldn't understand and appreciate what they were doing. In addition to that, there might be an allegation that the decedent was defrauded into signing a will or was unduly influenced by another person into signing the will, such that it wasn't really their voluntary, free act and knowing deed. Another way to challenge the matter might include a dispute over who should be the executor, also called the personal representative, the person who's going to be put in charge of managing the estate, paying off the bills, and then distributing the assets according to the will. Sometimes a challenge may include an allegation that a more recent will was found, a newer will that's different was found, and that it revoked the prior version of the will that somebody is trying to offer up for probate. And as a final example, a challenge might include a discovery of paternity or maternity, meaning that somebody alleges that they are a child of the decedent or a descendant of the decedent and were not identified as such in the will and should therefore inherit. Now, in the case where somebody died without a will, we call that dying intestate. A challenge may be filed in probate over who is appointed as the administrator of the estate, or exactly how the property is to be divided among the heirs under state law after the decedent's bills had been paid. An uncontested probate case, on the other hand, is a case where everyone involved is in agreement. The beneficiaries and the heirs are all in agreement as to who should be appointed to manage the estate, and when there is a will, in agreement about the admission of the will to probate. In short, uncontested probate means everyone goes along and gets along to get the estate settled. So that's a brief explanation of the difference between contested and uncontested probate. Here at Peach State Wills and Trust, we help our clients handle uncontested probate cases, primarily in Gwinnett, Barrow, Walton counties. If we can be of assistance to you with an uncontested probate case, I invite you to give us a call at 678-344-5342. And if you'd like additional information on estate planning or probate, check out the other videos here on our YouTube channel, as well as on our blog at peachstatewills.com. Thanks.